Okay, now we move on to identification and insurable interest. Under identification, there is 3 rules, and the first rule is 2501, which is insurable interest in goods and the manner of identification. Here there are 3 subsections. Subsection 1 reads, the buyer obtains a special property and insurable interest in goods by identification of existing goods to which the contract refers, even though the goods identified are non-conforming and they have the option to return or reject them. Such identification can be made at any time and in any manner explicitly agreed to by the parties. In the absence of explicit agreement, identification occurs A, when the contract is made, if it is for the sale of goods already existing and identified. B, if the contract is for the sale of future goods other than those described in C, then it's when goods are shipped, marked, or otherwise designated by the seller as goods where the contract refers. And C, when the crops are planted or otherwise become growing crops, or the young are conceived if the contract is for the sale of unborn young to be born within 12 months after contracting, or for the sale of crops to be harvested within 12 months, or the next normal harvest season after contracting, whichever is longer. Under subsection 2, the seller retains an insurable interest in goods so long as title to or any security interest in the goods remains in them, and where the identification is by the seller alone, they may, until default or insolvency or notification to the buyer that the identification is final, substitute other goods for those identified. Under subsection 3, nothing in this section impairs any insurable interest recognized under any other statute or rule of law. So in other words, in absence of an explicit agreement, identification occurs when the contract is made, if it is for the sale of goods already existing and identified. The process where the individual items become separated from the whole or other articles when they have been identified. CIF and CF terms, that's rule 2320 under the UCC, and under 2320, it says the term CIF, there's actually 4 subsections under here. And the first subsection reads, the term CIF means that the price includes a lump sum, the cost of the goods and the insurance and freight to the named destination. The term C and F means that the price so includes cost and freight to the named destination. Unless subsection 2 reads, unless otherwise agreed, and even though used only in connection with the stated price and destination, the term CIF destination or its equivalent requires the seller at his own expense and risk to put the goods into the possession of a carrier at the port of a shipment and obtain a negotiable bill of ladings covering the entire transportation to the named destination, and B, load the goods and obtain a receipt from the carrier showing that the freight has been paid or provided for, and C, obtain a policy or certificate of insurance, including any war risk insurance of a kind and on terms then current at the port of shipment in the usual amount, and D, prepare an invoice of the goods and procure any other documents required to effect shipment or to comply with the contract, and E, forward and tender with commercial promptness all documents in due form and with any endorsement necessary to perfect the buyer's rights. Subsection 3 reads, unless otherwise agreed, the term CNF or its equivalent has the same effect and imposes upon the seller the same obligations as and risk as a CIF term, except the obligation as to insurance. Under subsection 4, under the term CIF or C and F, unless otherwise agreed, the buyer must make payment against tender of the required documents, and the seller may not tender nor the buyer demand delivery of the goods in substitution of the documents. 2319, FOB and FAS terms. And here there are also 4 subsections. Unless otherwise agreed, the term FOB means free on board. At a named place, even though used only in connection with the stated price, is a delivery term under which, when the term is FOB, the place of shipment, the seller must at that place ship the goods in the manner provided in this article. B, when the term is FOB, the place of destination, the seller must at his own expense and risk transport the goods to that place and there tender delivery of them in the manner provided in this article. And C, when under either A or B, the term is also FOB, vessel, car, or other vehicle, the seller must, in addition at his own expense and risk, load the goods on board. If the term is FOB, vessel, the buyer must name the vessel, and in an appropriate case, the seller must comply with the provisions of this article. Under subsection 2, unless otherwise agreed, the term FAS, vessel, which means free alongside at a named port, even though used only in connection with the stated price, is a delivery term under which the seller must A, at his own expense and risk, deliver the goods alongside the vessel in a manner usual in that port or on the dock designated and provided by the buyer, and B, obtain and tender a receipt for the goods in exchange for which the carrier is under a duty to issue a bill of lading. Under subsection 3, unless otherwise agreed, in any case falling within subsection 1A or C or subsection 2, the buyer must seasonably give any needed instructions for making delivery, including when the term is FAS or FOB, the loading berth of the vessel, and in an appropriate case, its name and sailing date. The seller may treat the failure of needed instructions as a failure of cooperation under this article. He may also, at his option, move the goods in any reasonable manner preparatory to delivery or shipment. Subsection 4, under the term FOB, vessel, or FAS, unless otherwise agreed, the buyer must make payment against tender of the required documents, and the seller may not tender nor the buyer demand delivery of the goods in substitution of the documents.